We are delighted to have Judge Timothy Dyke from the U.S. Court of Appeals for the Federal Circuit here. Judge Dyke has been a judge on the Federal Circuit since the late Clinton administration, which I'm alarmed to say is an increasingly long period of time. I think of him as a recent appointee, but I realize that that's no longer true. We've had 6 appointees just in the last 6 years. He has, I think, developed a well-deserved reputation as an intellectual leader on the Federal Circuit. A number of his opinions are extremely influential, and his dissents are also influential in moving the Federal Circuit en banc, and in some cases moving the U.S. Supreme Court in a number of cases. And we are delighted to have him here, so please join me in welcoming Judge Tim Dyke.
Thank you, Mark. So I'm checking into the Stanford Park Hotel, which is where the panelists are being put up, and there's this nice gentleman who used to be a partner at White & Case, and he's also checking in. He says to the young lady behind the desk, he said, "Do you still have afternoon tea at 5 o'clock the way you used to?" She says, "No, we don't." 5 minutes later, we're still standing there. The woman says, "Hey, Jimmy, don't forget to get the glasses and the wine for the 5 o'clock wine tasting." And the guy says, "But why didn't you tell me, you know?" And she says, "You didn't ask about wine, you asked about tea." So I said to her, "What do you do in your spare time?" She said, "I'm studying to be a patent lawyer." I said, "Don't worry, you're halfway there already." Thanks to Stanford, the program in law, science, and technology, and particularly Mark Lemley for inviting me to speak here today. The topic of my talk is 10 prescriptions for what ails patent law. And before I get into the substance of it, I wanted to thank my law clerk, Alex Moss, who is here for her excellent help in preparing me to do this. Patent reform is an important topic, and President Obama said last February, I think, that we're halfway there in patent reform. I think that's a pretty generous estimate. But it really is important that the patent law incentivize investment rather than impair it. But it's also equally important that the solutions that are proposed and adopted avoid gimmicks, avoid regulation by anecdote, and avoid what I would call theoretical academic solutions to some of these problems. Last week, I presided over a patent trial in the Eastern District of Texas as a district judge. And yes, I did issue a Daubert ruling. And I was very impressed with the jury's competence and diligence in handling the complicated technical and legal issues, and it reminded me of the responsibility that the rest of us have to get the law right before we pass it into the hands of the jury. Now, currently patent law is framed against the background of 3 views that I think are held by the society at large and by the patent community in particular. And these views about technology and the law inevitably influence Congress in enacting legislation, the PTO in issuing patents, and the courts in adjudicating patent cases. The first of these is the widespread belief that innovation is the driver of the American economy and will remain central for a long time to come. And one estimate is that 18% of all jobs and 34% of the GDP is attributable to industries that are heavily patent dependent. The consensus is that technological innovation is crucial for productivity growth and that we're increasingly reliant on the production of ideas rather than the production of products to be the engine for our growth. And there's little dissent, I think, about this first view. But the second and third views are conflicting views. One of them sees broader patent protection and stronger patent enforcement as necessary to protect the U.S. economy and American inventors from unfair competition, both domestic and foreign. And that view holds that the creation and enforcement of strong intellectual property rights is necessary to foster innovation. And it's not an overstatement to think that some of those people believe that the patent system itself is the prime driver of innovation in this country. The opposing view, perhaps best represented by the graphic to my left, is that overprotection of intellectual property rights has been counterproductive and has impaired innovation instead of fostering it. And this is also, I think, a widespread attitude about copyright. These people don't see enforcing intellectual property rights as the best way to foster innovation and creativity. Now, these two views are at the heart of the debate over patent law. Both views have merit. Justice Breyer recognized in Mayo that patent protection is a two-edged sword. It can incentivize innovation with the promise of exclusive rights, and at the same time it can impede innovation by making consumer prices higher and restricting competition. Reforming patent law does not involve making a choice between one view or the other. Patent law must rather strike a delicate balance between the two and at the same time recognize that neither is served by a dysfunctional system for granting patents and adjudicating the scope of patent rights. My focus today is on the dysfunctional aspects of the patent system and on some proposals for making it better. Now, the first one is pretty simple. It's to reduce the PTO backlog. As of last month, the PTO had an unexamined patent application backlog of 600,000 applications. These are patents that are awaiting a first office action by an examiner. The total number of patent applications pending is greater, about 1.2 million as of last year. The size of the first figure, that is the $600,000 figure, poses the greater problem. It means that it takes an average of 18 months for an examiner to take any official action on a patent application. It took only 3 weeks, as Mark mentioned earlier, stealing my line, for Alexander Graham Bell to get his patent on the telephone. Today, applications are pending more than 2 years on average before action. Now, under Director Kapos, the PTO made major efforts to try to reduce the size of the application backlog with the goal of reducing the backlog of applications awaiting a first office action to 300,000 and of reducing the average wait time for first actions to 10 months. And obviously the PTO has not achieved these goals and doesn't seem to be likely to achieve them at any time in the near future. Now, to be sure, part of the problem is that there's a flood of new applications, 500,000 of them last year. Now, the fact that the PTO did achieve some success in reducing the backlog from 750,000 to 600,000 may not be entirely a good thing. And the reason for that is that there is a perception, and I heard echoes of that earlier today, a perception that the reduction of the backlog has come at the expense of patent quality. And others have written about that. The problem, in part, is that the PTO is this vast regulatory bureaucracy. It currently employs 12,000 people, and about 8,000 of those are examiners. There are 181 board members. The PTO is about the same size as the Department of Labor. The workload is staggering, not only if you look at examinations, but also appeals. The 181 judges on the appeal board decide over 12,000 appeals from patent examinations each year. That's an average writing task for the judges writing the opinions of about 70 or 80 per judge. And that's without accounting for the new work under the AIA. There's a real danger of not having the kind of quality control, given the numbers of employees, that's really essential, and a real risk that the way to reduce the backlog will be a further degradation in the quality of the patents that are issued. It's essential that we find a way to reduce the backlog without compromising patent quality. And one piece of good news is the proposed budget for next year for the PTO, which is $3.4 billion. All right, that brings me to my second prescription, and this was mentioned in some of the panel discussions earlier today, and that is that patent examiners have to do a much better job of policing claim drafting. Now, writing claims to describe an invention, I recognize, is an inherently difficult task. A new chemical compound can be described with simplicity and clarity, but most inventions cannot be so easily described in language. It often serves an applicant's interest to secure unclear claims that can be expanded by interpretation to cover new competitive technologies. And through continuations, applicants can indeed write or amend claims so that they cover competing technologies that were not even envisioned when the original application was filed. Construing claim language in poorly drafted claims continues to be a principal task of our court in patent cases. And both before and after Phillips, we continue to provide guidance on rules of claim interpretation. But the truth is that creating standards for claim interpretation is a very limited solution to the problem of lack of clarity. It's essential that the PTO take a much more active role in ensuring that claims are drafted to cover what they should and that they achieve maximum possible clarity. Now, historically, examiners did not view their role as one of ensuring clarity, except in those rare instances where a claim was viewed as being invalid, as indefinite. That may be changing. I've had some discussions with people at the Patent Office. There seems to be some recognition that it is important for the examiners to take a greater role in ensuring that the claims are drafted properly. And I don't mean here, as one suggestion was earlier, that the examiners will give their interpretation of the claim on the record so that people can rely on that later on. What I mean is rejecting the claims unless they are redrafted to be clear about what is required. The President's recent executive actions, which you heard about earlier today, seem to be encouraging in this direction and trying to get the examiners to be more systematic in strengthening patent examination and the language of the claims. Now, my third proposition is somewhat controversial, and that is that I would propose that the PTO be given a role in formulating substantive patent policy. At the present time, as you know, the PTO receives little deference from the judiciary. We have held that the PTO lacks substantive rulemaking authority. Congress, despite requests for substantive rulemaking authority in the AIA, did not give that to the PTO. and we have also the Supreme Court's decision in Hyatt, which held that the district courts could conduct de novo review of rejections in the course of district court proceedings. Now, as you all know, this is in stark contrast to the situation that we have with respect to other administrative agencies who have rulemaking authority and they earn Chevron deference to their interpretations of the statute. One of the difficulties that I see with the existing system is that the judiciary is not well suited to coming up with bright line rules. There's been some mention of the Supreme Court's reluctance to do that. It is hard for the judiciary to come up with bright line rules in some of these areas. The PTO, like any administrative agency, would be better positioned to do that. Now, to be clear about this, I'm not proposing that the PTO be given general substantive rulemaking authority. I think since the beginning of the Republic, since the beginning of the patent system, it has been the job of the judiciary to interpret these general statutes enacted by Congress with respect to patents. But what I am suggesting is that there may be limited areas, limited specific areas, where giving the PTO rulemaking authority might solve some problems. And even in the absence of that rulemaking authority, I think the PTO must do more in the way of issuing these examination guidelines, which are binding on the examiners but not the board, telling them what the rules are for examination. Now, my fourth point is that we must, as courts, make greater efforts to clarify the patent law. At the present time, and I've spoken about this before, patent holders and their competitors have to navigate a labyrinth of confusing decisional law. Patent doctrine often has no counterparts in other fields. It's rich with sui generis and unclear doctrine in areas such as obviousness, enablement, written description, the doctrine of equivalence, that have no counterpart elsewhere. And this lack of clarity is a particular concern because so many patent doctrines are questions of law. Claim construction, now again under lighting, ballast, and Cybor, and obviousness, prosecution history, estoppel, indefiniteness, so on and so forth. When Congress established our court in 1982, the purpose was to bring an end to inter-circuit conflict and to bring certainty to patent law. The idea was, to quote the House report, quote, greater certainty and predictability would foster technological growth and industrial innovation and would facilitate business planning, close quote. That objective has not been achieved to the extent that it needs to be. And the lack of doctrinal clarity makes it difficult for innovators to know where they stand, either when they sue or be sued or when they're developing new innovative products. Now, my fifth point is that it is essential to make the technology clearer in the course of patent litigation. We hear a lot about juries having difficulty with the technology, but the truth is that judges do also. It is an especially big area in areas of innovation where a large number of patents cover closely related technologies, and it becomes necessary to make fine distinctions between one technology and another. And in these patent thickets, understanding the difference between the old and the new is very, very difficult sometimes. Now, I don't have an easy solution to this. We rely on the bar to explain the technology, both to the jurors, sometimes using experts, and to us, sometimes using experts at the district court stage. And by and large, the bar does a pretty good job of it, but it really is important to focus on it. It is not a solution to give us scientifically trained law clerks, which we do have. The bar has to pay greater attention to explaining the technology in a way that is understandable. Now, the sixth point is the necessity of reducing the staggering costs of litigation, which you've heard a lot about earlier today. These costs threaten to limit entry to innovators with deep pockets and who can bear the risks not only of market failure, but of patent litigation. Damages in patent cases have exploded. Before 2012, only 3 awards hit the $1 billion mark. Since then, we've had 3 cases in 3 different districts with awards of $1 billion or more. And the real problem is not the size of the damage awards, but the cost of litigating. The number of patent actions filed has increased. From 2011 to 2012, the filings increased by almost 30%, reaching 5,189, the highest number ever recorded. And even in cases with less than $1 million at stake, median costs exceeded $650,000, and where the amount in controversy is in the millions, the legal fees are also in the millions. These enormous costs are imposed on innovators who have to forego or delay projects because of the costs of asserting patent rights or defending against asserted patent rights by others, and the society as a whole pays through lost innovation and unwarranted monopoly prices. To be cynical, but also to be realistic, we're not going to see much help from the patent bar itself in reducing these costs because the patent bar benefits from it. Now, the new AIE procedures for post-grant review and inter partes review may reduce these costs, and some district courts have limited discovery and trial time to control costs. In the Eastern District of Texas, as many of you know, each patent trial pretty much concludes within a week. Each side is given somewhere between 10 and 15 hours to litigate for direct examination and cross, and that seems, so far as I can tell, to work pretty well. And it works well without sacrificing the ability of counsel to present complex cases. It forces party to litigate only those issues that are truly dispositive and in many cases contributes to better advocacy. I mean, it's the old saying about writing a brief. I had to write a 50-page brief because I didn't have time to write a 25-page brief. And that problem exists with lengthy patent trials as well. Now, my 7th prescription is that patent reform should include broadening the base of participation and public involvement in the patent system as a whole, and I think this is really important. Right now, the patent system is largely based on regulation through adversarial court litigation and PTO proceedings. And as a rule, the only interests that are represented are those of the patent holder and its competitors, or in the case of patent assertion entities, the entity owning the patent and the people being sued, the plaintiffs and the defendants. Amicus filings, even in the in-bank cases that we get and that end up in the Supreme Court, are largely limited to associations of patent owners or bar associations consisting of patent counsel. An insular community out of the public spotlight is one that will have serious problems. The exceptions to insularity are few and far between. The FTC, of course, became involved in the reverse payments dispute. The ACLU and the Justice Department We're involved in the Myriad litigation. The Electronic Frontier Foundation has been involved in some cases. But by and large, those representing the interests of consumers or government antitrust enforcement are not represented even in amicus filings. And in my view, the system needs greater policy and empirical input from those with divergent interests. Now, my eighth point is the need to embrace the Supreme Court's increasing involvement in patent law. In recent years, as you all know, the Supreme Court has shown a good deal of interest in patent cases, and typically they have several every year. This year they have 5 of them. And these cases have implicated a range of issues that touch on every area of patent law and affect our work and the work of the district courts. Now, strangely enough, the involvement of the Supreme Court is not welcomed by the patent bar. And I think that laughter just confirms that. A standard applause line, so far as I can tell in bar gatherings, is to criticize the Supreme Court for not understanding patent law and indeed for having the temerity to grant cert in the first place in these cases. I think that's misguided. I think the bar and the patent community ought to welcome Supreme Court review. There certainly is room to have a better informed Supreme Court on some of these issues, but I think it's essential. And that's true, I think, for 3 reasons. First, the court has a broader perspective than we do at the Federal Circuit. The Supreme Court has consistently criticized the extension of patent exceptionalism into areas where convergence with conventional legal rules is possible and preferable. And reconciling the differences between patent laws and patent law in other areas remains an important task of the Supreme Court. I'll give you an example from what happened earlier today, all this discussion of shifting attorney's fees. I think there was one question, well, why can't we have attorney fee shifting in frivolous cases in other areas? And one of the panelists said, well, we can't address that. What about Rule 11? You know, there is such a thing. There's Rule 11, which allows fee shifting in frivolous cases in other areas. What's the matter with Rule 11? Why doesn't it work for the patent community? That's an issue which ought to be addressed instead of simply treating the fee shifting issue as being unique to patent law. Second of all, the Supreme Court in patent law, as in other areas, is the only entity that can establish uniformity and bring clarity to legal questions. A current example is the division of our court in the CLS case on subject matter standards. And having failed to resolve this issue, in my mind, it was essential that the Supreme Court grant review and provide some guidance. And the third point as to why Supreme Court review is important has to do with the fact that we have only a limited ability to change our own longstanding jurisprudence. Only the Supreme Court can step in if some of this jurisprudence is ossified and change it. So I think the Supreme Court's role here is important. I think they will continue to play a role, and I think we should welcome it. At the same time, trying to have them better understand what the landscape is that they're navigating. Now, my penultimate point is that we need to pay greater attention in litigation to patent policy. Because of the very general nature of most of the patent statutes, Hatch-Waxman and a few others aside, in interpreting those statutes, we must be guided by general policy considerations articulated by Congress. Many see congressional policy as favoring ever-increasing patent protection based on the faith that more protection is necessarily better. The other half of the world has a faith that if only patent trolls, as they're called, could be controlled, everything would be fine. Neither view is correct. There's a need to move from faith-based approach to patent law to a more practical and policy-oriented decision-making. And the need for a greater focus on practical policy concerns, I think, can be illustrated by an example, and you could have many. Let us suppose that inventor A filed a patent application for the use of compound X in an industrial process. No one has done this before. Adding X to the process speeds up the process by 1%, but the cost of using the compound is very high. The patent issues, but the claim process is never commercialized because of the small benefit and high cost. The technology covered by the patent is, in the real world, completely worthless. Now, a few years later, inventor B comes along, and he discovers that adding compound X and compound Y together to the process increases speed by 200%, and it revolutionizes the industry. Inventor B never knew about A's patent, never knew about anyone using compound X in the process, and given the speed of the new process, the use of compound X is economical. Now, under existing patent law, inventor A was entitled to his patent, and it's a comprising patent typically. And inventor B cannot practice his invention without a license from A, even though B himself can get a patent on the combination. A's blocking patent reads on any use of the process with compound X. Even though this makes perfect sense to a patent lawyer, there's a question as to whether it should make sense in the real world. And it raises a question, for example, as to whether there's a reason to have a stronger utility requirement to get a patent in the first place. We take account of the value of the patent in connection with some of the secondary considerations for obviousness and in connection with damages awards, but maybe we should be taking it into account in some fashion in determining whether the patent should be granted in the first place, or whether, if it is granted, it ought to be able to be continued to be asserted. Now, currently, as we heard earlier, patent examination, and this is not only true of the limited inter partes and post-grant review proceedings, but patent examination itself focuses largely on prior art and on anticipation and obviousness, and to some extent on patentable subject matter. But perhaps there's a need to ask whether a particular patent that's being sought is really going to contribute significant knowledge or value in the marketplace. In other words, whether it has the utility that's required by the patent statute. Now, by the way, my example, I think, is not far-fetched. It describes many patents that are asserted by entities that are the subject of this conference, non-practicing entities. And instead of looking to the substantive patent law, often the proposals to deal with patent abuse focuses on fee shifting or joinder or other procedural points. And I suggest to you that it is essential to focus more on the substantive patent law that governs the issuance and validity of these patents in the first place. The difficult work of patent law, as Thomas Jefferson recognized long ago, is drawing, quote, a line between the things that are worth to the public the embarrassment of an exclusive patent and those which are not. And substantive patent law needs to be refined in a way that it gives better answers to those questions. Now, my 10th and final point is addressed both to the bar and to the academy, and that is that we need better input from both the bar and the academy. With respect to the bar, I think the truth is the bar is too timid and too lacking in creativity. And I'll give you a couple of examples. One was recently in lighting ballast during the oral argument. Some of us were rather surprised to see that the party supposedly defending de novo review didn't. The party defending de novo review said, well, it ought to be tweaked in these ways, but we shouldn't completely abandon cyborg. And I asked in the course of the oral argument, so what are you saying? You're assuming that we've already decided to abandon cyborg, right? And sort of mumble. You know, I mean, here we have a case in which we were looking for adverse positions, and sort of one of the parties, by psychoanalyzing the court, supposedly figured out that we were going to overrule cyborg, and the question was, how do you limit the damage? And of course, it didn't turn out to be the case. We have reaffirmed cyborg. The other example I'd give is in the area of patentable subject matter. It was not until the metabolite case in the Supreme Court and our own decision in Kaminsky that focus was again placed on patentable subject matter after decades of neglect. And the question is, why didn't the bar raise that? In the metabolite case, the issue was not raised before us, which is why the Supreme Court dismissed the case as improvidently granted, ultimately. Those are just a couple of examples. But I heard earlier today one of the panelists say that you're trying to get the outside lawyers to raise some of these points. They say, oh, don't raise that. That's not going to work. But in fact, there are all sorts of things that deserve exploration. I mentioned to one of my colleagues today, I said, I'm going to raise this point at this conference. And my colleague said, oh my goodness, don't do that. Don't you remember the X, Y, and Z case that we had recently where people raised these crazy policy arguments that had no chance of succeeding? And that's true. We do sometimes get policy arguments. Mostly they're so strange that they have no chance of being adopted. But I do think it's essential that the bar focus more on what actually can work and to present some of those issues to us, to the district courts, to the Supreme Court, in a way that has some chance of moving the ball forward. And I'd say the same thing to the Academy. There has been good work done in the Academy, particularly recently, but still too many of the articles that are written which come across my desk are overly theoretical and disconnected from the real world. They are addressed to a regime that is unfamiliar to me. And I think the Academy has to be more practical, has to be more attuned to the realities of litigation. I think conferences like this are very valuable in helping to bring that about, to have the exchange between the bar and the Academy so we can all come up with some solutions and proposals that make patent law better. And even thank you very much. I'll take some questions if we have time for that. But no questions about how's my case going to be decided.
Full of errors, thank you, on the examiner's part. So in one case, he forgot to examine a claim. In another case, there's just typos everywhere. In another case, the wrong box is checked. And I would think that when something like that goes to a court, those errors compound and cause additional time to be wasted, additional money to be spent. So when are we going to have an upgraded USPTO? When are we going to have a PACER system that lets us actually see what's being litigated and why? Because those issues, to me as an inventor, are hugely important, and they're extremely expensive to get around. And to just add one final piece of context, in December 1968, which was before I was born, Doug Engelbart demonstrated copy and paste functionality in his famous demo. Today, in 2014, you can't copy and paste from an office action. it's impossible. So, you know, I appreciate all your suggestions, all 10 of them. I think they're very good, but I think an 11th needs to be the technological infrastructure that this whole business revolves around, because it's an information business, and the information tools just are not there right now.
Well, there's no question that the quality of the examination is crucial. I mean, one of the things about our limited jurisdiction is that those kinds of questions really don't come before us, that your plea for better examination, which I agree with, is something that needs to be addressed to the patent office, that inventors need to address to the patent office, and hope that they can do something that's responsive. I mean, they certainly are taking this seriously. They certainly do know that there are problems with the quality of the examinations, and I think if you hold that view, that writing to the director or the acting director about that is the sort of thing that would be helpful. I do think it's really important for the innovation community to make its views known on these things, and I think there is a tendency not to do that, in the sense that feeling that the system can't change and won't change. But I think you got to speak up. That's what it's all about. Any other questions? All right. I've answered all your questions. All right. Thank you very much.